let's turn our mind to what can someone do when there's been a breach identified. We're talking about legal remedies here, and clients are always very interested to know what their rights are and what remedies are available. And I'll outline a few common ones. We look at things under the common law first. Commonly, the first two that I see regularly is things like damages claims for money. And the purpose of damages is to put you in the position you would have been if the contract was honoured. It's not to make you a millionaire, contrary to popular belief. It's to put you in the position you would have been. And another thing we see commonly is restitution. So payment for work done. If the contract was, for example, frustrated or avoided, people are often wanting to be paid. And so, these are common remedies. And then we've got on the other sphere, we've got equity. So when the court draws on its equitable jurisdiction and its powers, there could be broader remedies and maybe filling in the gaps that the common law fails to address. And those are things like specific performance. This means forcing the other party to do what they promised and enforcing the contract and keeping it on foot. It's just a few examples. There's obviously there's a huge body of case law on remedies. So just trying to give some very common examples there.
Yeah. And another one that comes to mind as well is with the criminal jurisdiction, and you touched on this earlier, that
Yeah.
the civil claim is essentially, and if there is a civil claim, is essentially waiting for the result of the criminal matter. So if you're the victim in a criminal matter and you're waiting for the accused to be proven, or the court to prove that what he did or is offending um, has been proven by a court, they wait for that because then that can essentially solidify their civil claim later on. And it's important because when I'm giving advice to criminal clients, I often have to look at this and forecast this to go, look, you might be here, you might just see this as reckless causing serious injury, but you've got to look at the bigger picture.
Well, we alleged criminal
Correct.
clients.
Alleged criminal clients.
Yeah.
You got to always look at the bigger
Just
picture.
throw that one in there.
Yeah, correct. Now you've always got to look at the bigger picture, and you've always got to say, look, yeah, this is one matter we're looking at, but if your instructions are to plead guilty, then these are the consequences that can stem from that.
It leads into that point. If you look at equitable remedies in the civil jurisdiction, you've got, what would be an example? Criminal restitution matters that flow on from a criminal case, like, for example, maybe under the Sentencing Act in Victoria, or where the prosecution, the police are seeking those as part of financial crime is quite common, and it may be that it's actually codified in the legislation, for example, in the Sentencing Act, for victims where there's a conviction, so it might be slightly different, but it's still a similar remedy that you see, isn't it?
Yeah, correct. It's a similar remedy, just have different terminology, obviously, for it, which makes it very confusing for a lot of civilians who don't know the law that well. And sometimes, let's face it, Michael, sometimes it is confusing for sometimes some lawyers in different jurisdictions in law because we're not across everything. We know, generally what the law is, but for specific areas, it can be quite specific that we look at it and we think, okay, we've got to research this a bit more. But no, you're right. The remedies are quite similar across the board. Yeah, correct.
I had one case example where a building contractor, whose client walked away after 90% of the work was done. We issued a letter of demand. We preserved the evidence, and we got a judgment in under 90 days through the process of just choosing the right court, and in that case, it was the county court. But subsequently, the defendant didn't put in a defence or an appearance, and so it was effectively a judgment in default of appearance. That process, and there was a bit of a different process in the county court that needs to be followed with that. under the court rules, and you need to look at the practice note. So that was a great example of a situation where there was clearly a breach in the sense that there was non-payment, but achieving a positive outcome because we're moving quickly, and sometimes moving quickly is important, isn't it?
Correct, correct. And an example I'll give is more about early intervention, and it goes back to the case I had between a landlord and a tenant for a commercial lease. And the same example, the tenant was in a 10-year lease, 5 years on one lease and followed by 5 years in another. And it all came down to once he found out that his bond hadn't been invested in an interest bearing account, what he needed to do. And it wasn't until he came back to me later on after giving advice and said, if only I got legal advice at the beginning of my second 5-year commercial lease, it would have made a big difference, because the advice I would have given was it's your duty to make sure that that bond has been invested by the landlord solicitor as per the contract. And you need to calculate, they should give you bank statements. You need to calculate how much that interest is, because if you're on top of it, we wouldn't be having this discussion now on how we're going to get that percentage of, I think it was close to around $40,000 he had to put up as a bond, which had been sitting in a solicitor's trust account, not earning any interest.
Look, hindsight's a beautiful thing. We say it quite frequently, isn't it? It's you're never going to be able to predict everything, and we're lawyers. We don't have a crystal ball. Some of us are better than others and pay more attention to detail and care more for our clients' interests, like our business does, and yours as well, Alan. But no one's perfect, so there will be issues that arise, and there's nothing that you can do about some of them except for try and deal with it properly when it arises.